If you're watching this right now, stop whatever you are doing, because what I am about to share with you could completely change your future plans for living and working in America. Whether you are currently on an H-1B visa, whether you are an employer sponsoring skilled workers, or whether you are one of the hundreds of thousands of people who filed for the H-1B lottery this year with hope in your heart, you need to hear every single word of this video, because the rules have changed, and not in your favor. The H-1B visa has long been called the golden ticket to the American dream for skilled foreign workers. Engineers, software developers, doctors, nurses, researchers, scientists, millions of people around the world have built their entire career strategies around winning the H-1B lottery. They spent years getting the right degrees, building the right skills, finding the right employer sponsors, paying thousands of dollars in legal fees, and then holding their breath every single spring waiting to find out if luck was on their side. For most of them, it never was. The odds were already brutal. But now, the system has been fundamentally restructured in a way that makes it nearly impossible for average applicants to compete. Let me take you back for just a moment so you understand how we got here. The H-1B visa program was originally designed to allow American companies to hire highly skilled foreign workers when qualified Americans could not be found to fill those roles. The annual cap was set at 65,000 visas, with an additional 20,000 reserved for people who hold advanced degrees from American universities. That sounds like a lot until you realize that in recent years, USCIS has been receiving anywhere between 400,000 and 780,000 registrations for those 85,000 available spots. That means in some years, your chances of being selected were as low as 1 in 9. Imagine training your entire life for something and being told you have a roughly 11% chance of even getting through the door. And for years, that randomness, that pure lottery luck, was the only thing standing between a qualified skilled worker and their American dream. It did not matter if you were a genius. It did not matter if you had a PhD from MIT. It did not matter if your employer was desperate to hire you. If the random number generator did not pick your registration number, you were going home, or staying home, or trying again next year, and the year after that, and the year after that. But here is where things take a dark and deeply troubling turn for 2026 and beyond. USCIS has now introduced a wage-based lottery selection system that completely overhauls how registrations are ranked and selected. On the surface, the government will tell you this is a reform. They will tell you this is about protecting American workers, about ensuring that H-1B visas go to the most highly compensated, most highly valued foreign workers. But when you dig into what this actually means in practice, the picture becomes very different, very alarming. Here is how the new system works. Under the wage-based selection model, your number of chances in the H-1B lottery is no longer equal to everyone else's. Instead, the number of lottery entries you receive is directly tied to the wage level of the position you are being sponsored for. The Department of Labor classifies H-1B positions into 4 wage levels. Level 1 is for entry-level workers who are just beginning their careers. Level 2 is for qualified workers with experience. Level 3 is for experienced workers. And Level 4 is for fully competent workers at the top of their profession, the most specialized, the most experienced, the highest paid. Under the new rules, if your employer is sponsoring you for a Level 4 position, the highest wage level, your registration is entered into the lottery 4 times. If you are being sponsored for a Level 3 position, your registration goes in 3 times. Level 2 gets 2 entries. And Level 1, the most common wage level under which the vast majority of H-1B applicants have historically been sponsored, gets only 1 single entry into the lottery. Now think about what this means. If you are a freshly graduated software engineer being sponsored by a small or mid-sized tech company at a Level 1 or Level 2 wage, you are now competing in a system specifically designed to push you to the back of the line. Meanwhile, Applicants being sponsored at level 4 wages, which typically means salaries well above $100,000, in many cases above $150,000 or even $200,000 per year, those applicants now have 4 times the statistical advantage over you. 4 times the chance of being selected. 4 times the chance of having their dreams come true, while yours get quietly buried under the weight of a system that was supposedly reformed to be more fair. And here is the question nobody in the mainstream conversation is asking loudly enough. Which industries and which workers does this hurt the most? The answer will shock you. Healthcare, scientific research, academia, nonprofit organizations. These are the sectors where salaries are traditionally lower, not because the work is less valuable, but because of how these industries are structured. A nurse being sponsored for an H-1B visa does not earn what a senior software engineer at a major tech corporation earns. A research scientist at a university laboratory does not pull in the same compensation as a machine learning engineer at a billion-dollar startup. A physical therapist, an occupational therapist, a medical technician, these are critically needed professionals. The United States has a desperate shortage of healthcare workers. Hospitals across this country are begging for qualified staff. And yet, under this new wage-based system, the very workers who could fill those critical gaps are now the least likely to be selected in the lottery. Think about that for a moment. The people America needs most, the nurses, the researchers, the educators, the scientists who are working to cure diseases and advance human knowledge, they are now being systematically disadvantaged by the very program that was supposed to bring the world's best talent to American shores. And it does not stop there, because the wage-level system also creates a deeply unequal playing field between large corporations and small businesses. A giant technology company with billions of dollars in revenue can afford to sponsor H-1B workers at level 3 and level 4 wages. They have the legal resources, the HR infrastructure, the financial capacity to offer premium compensation packages that qualify for the higher wage levels. But a small business, a startup, a community hospital in a rural area? These employers often simply cannot afford to pay at the level 4 wage tier, which means their sponsored employees are entering the lottery at a disadvantage before the selection process even begins. This is not a level playing field. This is a system that systematically rewards the already wealthy and punishes everyone else. Now let's talk about the numbers, because the numbers tell a story that should make every H-1B hopeful extremely worried. In past lottery cycles before these wage-based reforms, the selection rate hovered somewhere between 11 and 27%, depending on the year and the volume of registrations received. For fiscal year 2026, USCIS received registrations in massive numbers. With the new wage-weighted system now in play, analysts are already projecting that the effective selection rate for level 1 wage applicants could drop to single digits. We are potentially talking about a 5 to 7% chance of selection if your employer is sponsoring you at the entry-level wage tier. That is not a lottery. That is a lottery designed for you to lose. And here is another layer that most people are not talking about: the social media screening. As of 2026, the State Department has now expanded its online presence review requirement to include H-1B workers and H-4 dependents. What does that mean? It means that when you apply for your H-1B visa stamp at a consulate or embassy, you are now required to disclose your social media identifiers, your usernames, your handles across platforms. Immigration officers will review your online activity, posts you made 5 years ago, opinions you expressed, content you shared, groups you belong to. All of it is now potentially part of your immigration record. This is not a small thing. This is a fundamental expansion of government scrutiny into the private digital lives of visa applicants. And the terrifying reality is that nobody knows exactly what the thresholds are. Nobody knows exactly what kind of online content will trigger additional scrutiny, further delays, or outright denial of a visa. The lack of transparency around this policy is itself a form of control. Because when people do not know where the line is, they police themselves. They self-censor. They live in fear. And fear is exactly what is driving the conversation around H-1B visas in 2026. Fear among applicants who do not know if their registration will be selected. Fear among employers who do not know if the workers they are counting on will be approved. Fear among families who have been separated for years, waiting for visa approvals that may never come. There is also the matter of increased vetting and the new USCIS vetting center that was announced earlier this year. This centralized vetting operation was designed to consolidate and enhance the screening of immigration applicants for national security concerns. Again, on the surface, this sounds reasonable. Nobody wants bad actors to enter the country through the visa system. But the practical consequence of centralized enhanced vetting is longer processing times, more requests for additional evidence, more opportunities for bureaucratic delay, and ultimately fewer approvals getting through the pipeline in any given fiscal year. If you are an H-1B applicant who has been waiting years for a green card, waiting in the employment-based backlog, which for applicants from countries like India and China can stretch to decades, yes, decades, then the additional processing delays created by enhanced vetting are not an inconvenience. They are a life sentence of uncertainty. They mean missing milestones. They mean children aging out of dependent visa status before a parent's green card is approved. They mean career decisions made not on the basis of opportunity, but on the basis of visa status anxiety. So where does this leave you? If you are an H-1B applicant or an employer who sponsors H-1B workers, what do you actually do with all of this information? The first thing you need to understand is that the landscape has permanently shifted. The era of treating the H-1B lottery as a somewhat fair random process is over. The new wage-based system is here, it is real, and it fundamentally changes the calculus for every stakeholder in the H-1B ecosystem. If you are an employer, you need to seriously evaluate whether the positions you are sponsoring can be reclassified at a higher wage level, not fraudulently, not by inflating job duties artificially, but by genuinely reassessing compensation structures to ensure your sponsored workers are positioned as competitively as possible in the new system. If you cannot offer a level 3 or level 4 wage, you need to go into the lottery with your eyes open, understanding that the odds are now stacked higher than ever against your registration being selected. If you are an individual applicant, you need to be working with an experienced immigration attorney, not a notary, not a document preparer, not a friend who went through the process 5 years ago when the rules were different. You need a licensed immigration attorney who is actively tracking these regulatory changes in real time and who can give you specific personalized advice about your situation, your wage level, your employer, your country of birth, and how all of those factors interact under the new rules. You also need to be thinking about alternative pathways. The H-1B is not the only route to working legally in the United States. Depending on your situation, there may be other visa categories worth exploring. The O-1 visa for individuals with extraordinary ability in their field. The L-1 visa for intra-company transferees. The TN visa for Canadian and Mexican professionals under certain trade agreements. The EB-1 green card category for individuals who can demonstrate extraordinary ability or outstanding research. These pathways are not easy. They are not cheap. But in an era where the H-1B lottery has become an increasingly hostile system for average wage applicants, diversifying your immigration strategy is not optional. It is essential. And if you are watching this from outside the United States, weighing whether to even attempt the H-1B route for 2026 or 2027, you need to make that decision with a clear and honest assessment of the odds. The dream of working in America is not dead, but the door is narrower than it has ever been, and the people guarding that door are checking more boxes, asking more questions, reviewing more social media posts, and approving fewer applications than at any point in recent memory. The H-1B lottery was never perfect, but what it is becoming in 2026 is something far more troubling than an imperfect system. It is becoming a system that privileges wealth, penalizes need, and makes the path to American opportunity narrower with every passing regulatory update. Stay informed, stay prepared, and make sure you subscribe to this channel because the immigration landscape is changing faster than most people can track, and missing one update could cost you everything. We will be right here, cutting through the noise, bringing you the facts, and making sure you have the information you need to protect your future.